Hello, good evening, and welcome to BYJU'S Exam Prep. Welcome to Target Prelims 2023. Today is lecture 3 on Indian Polity. So without wasting time, let's get started and look at question number 1. Which of the following departments are part of the Ministry of Finance? Department of Disinvestment and Public Asset Management has been in the news for a long time now because of some disinvestment targets. Look at the question and let me know what is the right answer. Department of Expenditure, yes, it is part of Ministry of Finance, Department of Revenue, and we have discussed previously that Enforcement Directorate comes under the Department of Revenue. Department of Revenue. Then we have Department of Economic Affairs, and this department is responsible for the preparation of budget. Department of Financial Services, yes. Department of Public Enterprises and Department of Investment and Public Asset Management, D. All of the above is the right answer. One more important thing, it was during the budget speech of 2016-2017 that Department of Disinvestment was renamed as Department of Investment and Public Asset Management. DIPAM. Previously, it was referred to as Department of Disinvestment. So D, all of the above is the right answer. Let's look at question number 2. Which of the following is or are the terms of reference of the Law Commission of India? Law Commission of India is a non-statutory body, and a non-statutory body is set up on the basis of the resolution passed by the Government of India. So you should know that there are constitutional bodies, for example, Election Commission of India, Union Public Service Commission. A constitutional body is a body which is created by the Constitution. Either it was originally part of the Constitution or Constitution was amended under Article 368 by the Parliament and a new constitutional body can be created. For example, we have discussed 102nd Constitutional Amendment Act created a constitutional body known as National Commission for the Backward Classes. Clear? Or a body can be a statutory body. A statutory body is a body which is created by the law passed by the Parliament. For example, National Human Rights Commission is a statutory body. Then there can be bodies which are neither mentioned in the Constitution nor are created by a parliamentary law, but these bodies are created by a government resolution. For example, previously we used to see Planning Commission. It was a non-statutory extra-constitutional body created by a government resolution. It was replaced by the Niti Aayog. And Niti Aayog, which is a think tank of the Government of India, it is also a non-statutory extra-constitutional body. Similarly, the Law Commission also is a non-statutory extra-constitutional body created by a government resolution. And currently we are in 22nd Law Commission. And you should know that the first Law Commission in the colonial period, during the colonial era, it was led by Lord Macaulay. Clear? But one more interesting thing, can anyone tell me who is going to be the chairman of the Law Commission? If I give you a statement that the chairman of the Law Commission of India necessarily has to be an ex-judge of the Supreme Court or an ex-Chief Justice of India, would that statement be correct or incorrect? Anyone? Incorrect, yes, incorrect, correct. It is not necessary that the Law Commission should be headed by a former judge of the Supreme Court or a former Chief Justice of the Supreme Court of India. For example, the 22nd Law Commission is headed by a former Chief Justice of the Karnataka High Court. So you have to be absolutely clear that the Law Commission of India, which is an extra-constitutional body, non-statutory body, created by a government resolution, established via a government resolution, it need not be necessarily led by a former judge of the Supreme Court or a former Chief Justice of India. A former judge or a Chief Justice of a High Court can also be the head of the Law Commission. Now, which of the following is or are the terms of reference of the Law Commission of India? Number one, to examine the laws which affect the poor and carry out post-audit for socio-economic legislations which are responsible for shaping the society and economic development of the society. Number one. Number two, to examine the existing laws in the light of directive principles of state policy and to suggest ways of improvement and reform, and also to suggest such legislations as might be necessary to implement directive principles and to obtain objectives set out in the preamble of the Constitution. Third statement, examine the existing laws with a view for promoting gender equality. And statement 4, to examine the impact of globalization on food security. If you look at the website of the Law Commission of India, it says that all these 4 are the terms of reference of the Law Commission of India. So which means D, all of the above is the right answer. And Law Commission of India has been in the news for quite some time now, primarily because of Uniform Civil Code. There are various state governments which are trying to bring about their own Uniform Civil Code, and for that Law Commission previously had said in one of its reports that it is not desirable to implement Uniform Civil Code right now. That is why Law Commission of India is in the news. Also, Honorable Home Minister Mr. Amit Shah has said that we will review all the existing laws and take a look at all those laws which are obsolete now, which are not required now, and we will seek the recommendations of the Law Commission of India to delete all these obsolete laws. That can also be the terms of reference of the Law Commission of India, which means D, all of the above is the right answer. Let's look at question number 3. Offences which carry maximum of more than 7 years imprisonment but no minimum sentence of fewer than 7 years. These are known as heinous offences. Is this statement correct? Petty offences are those for which the maximum punishment under the Indian Penal Code or any other law in force is a fine. Which of these statements is or are correct? For that, let me tell you something about offences. Offences can either be cognizable or offences can be non-cognizable. Which are these cognizable offences? For example, an offence where the police can arrest you even without the warrant by the court, where the police can carry out investigation even without the necessary permission of the court, that is what we call a cognizable offence. But if there is a non-cognizable offence, then the police cannot arrest you without the warrant issued by the magistrate. The police cannot carry out the investigation without the approval from the concerned magistrate. Those are what we call non-cognizable offences. And defamation, my dear, is one such non-cognizable offence, which means without the approval of the concerned magistrate, the police cannot carry out the investigation. Without the warrant issued by the magistrate, the police cannot arrest an individual. That's what we call cognizable and non-cognizable offences. But then there are offences which can be categorized into petty, serious, and heinous. Can you tell me what are these petty offences? Petty offences are those for which the maximum punishment is imprisonment for a period of 3 years. Punishment, minimum punishment of more than 3 years. Those are known as serious offences. And heinous crimes are those for which the minimum punishment is 7 years. Why? Because there has been some recent change ordered by the Supreme Court on this matter, and that is why this becomes important for your upcoming prelims examination. Let me take you back to 2015. When a law was passed known as juvenile justice, Care and Protection of Children Act 2015. According to that law, and that law was passed primarily because of the Nirbhaya gang rape, because one of the accused in that case was a juvenile who was just few months short of 18, because prior to that we had a Juvenile Justice Act under which if a juvenile who is less than the age of 18 has committed any crime, this juvenile cannot be treated like an adult, which means the maximum punishment that can be given to this juvenile is 3 years, that too in a reform home, not in a regular jail, because you have to separate adults from juveniles, because juveniles are of impressionable age. But once this juvenile was responsible for a heinous crime such as the gang rape in December 16, 2012, Nirbhaya gang rape, then the law was changed. And then this law says a juvenile who is in the age group of 16 to 18 years, and if this juvenile commits a heinous crime, then this juvenile may be tried like an adult. If I give you a statement, a juvenile who is in the age group of 16 to 18, if this juvenile commits a heinous crime, then this juvenile shall be tried like an adult. Is this statement correct? This statement is incorrect. Because a juvenile in the age group of 16 to 18, if this juvenile commits a heinous crime, and what is a heinous crime? For which the minimum punishment is 7 years, then this juvenile may be tried like an adult. And for that we have to seek the report of a body known as Juvenile Justice Board. Juvenile Justice Board will conduct the analysis of this juvenile and see whether his psychology is that of an adult, and then give up a report and say, yes, this individual, this juvenile can be tried like an adult. There was a case before the court where there was a juvenile in the age group of 16 to 18. He had committed a crime, and that crime is known as culpable homicide not amounting to murder, which comes under section 304 of Indian Penal Code. In this section 304 of Indian Penal Code, the punishment is given of more than 7 years. Listen to me carefully. Punishment is given of more than 7 years, but there is no minimum punishment prescribed. That means if you are sentenced under section 304 of Indian Penal Code, the punishment can be up to 10 years. That means the maximum punishment can be up to 10 years, but no minimum punishment has been prescribed. And the Supreme Court has now clarified that all such offences where maximum punishment is anything more than 7 years, but no minimum punishment has been prescribed, such an offence is not a heinous offence. Such an offence is only a serious offence. Long story short, an offence for which no minimum punishment has been prescribed, no minimum punishment of more than 7 years is prescribed, such crimes are known as serious crimes. They are not known as heinous crimes. So statement number 1 is incorrect. Petty offences are those for which the maximum punishment under Indian Penal Code or any other law in force is a fine. This is incorrect. Why? Because the maximum punishment for a petty crime is an imprisonment for 3 years. So which of the above statements are correct? D. Neither 1 nor 2 is the right answer. Yes, Verma Commission was set up in the aftermath of the Nirbhaya gang rape. It's suggested, and that is how Criminal Amendment Act was passed in 2013. Various changes were made to our criminal jurisprudence. Now let's look at question number 4. Which of the following statements is or are correct regarding memorandum of procedure of appointment of the Supreme Court judges? For that, let me tell you a brief background about the appointment of judges to judiciary. And you should know whether you have to appoint a judge to a Supreme Court or High Court, the process is same. And what is the process? Every judge of the Supreme Court or a High Court is appointed by whom? Appointed by the President of India. Previously, the system was a senior-most judge of the Supreme Court was appointed as the Chief Justice of India by the President of India. But then we saw that this convention Convention in the sense it's an unwritten rule. It is not mentioned in the Constitution. Constitution only said that the judges of the Supreme Court and High Court shall be appointed by the President. And while appointing the judges, the President shall consult such of the judges of the Supreme Court and High Court as he may deem necessary for the purpose. Which may also mean that the President is not bound to consult anybody while appointing judges to the Supreme Court and High Court. But the same Constitution says, when a judge other than the Chief Justice of India is to be appointed by the President, the Chief Justice of India shall be consulted. So it is necessary to consult Chief Justice of India by the President when other judges to the Supreme Court and High Court are to be appointed. And we were following some conventions where a senior most judge of the Supreme Court in terms of seniority, not in terms of age, in terms of seniority was appointed as the Chief Justice of India. But in 1973, after the Keshavananda Bharati verdict, when Justice Sikri retired, then a new Chief Justice of India was to be appointed. The President, instead of following the seniority principle, appointed Justice A.N. Ray, who was at serial number 4 in terms of seniority as the Chief Justice of India. And those 3 judges who were senior to Justice A.N. Ray, they resigned in protest. So this convention got broken. Then we also saw in 1976, when a landmark judgment, which was later on overturned by the Supreme Court, which some people say is one of the black spot on the history of India's Supreme Court, known as Idiom Jabalpur case or habeas corpus case, where the Supreme Court said, 4 judges of the Supreme Court out of 5 said that habeas corpus can be suspended even during emergency. There was only one judge who dissented, Justice H.R. Khanna. And he was all set to be appointed as the Chief Justice of India because of the seniority principle. But then he was not appointed. Justice Beg was appointed as the Chief Justice of India and Justice Khanna resigned in protest. But be that as it may, initially the ultimate control, ultimate power of appointing judges to the Supreme Court, to the High Court was vested with the executive. And this changed because of second judge's case. Second judge's case, which is also known as the Sakara versus Union of India, Supreme Court Advocates on Records Association versus Union of India, 92-93, in which the Supreme Court invented something known as collegium system for judicial appointments. This collegium system was given further stamp of authority by another judge bench known as third judge's case in the year 1998. And now the combined effect is, if there is a vacancy in the Supreme Court of India, who is responsible for initiating the process to fill this vacancy? Not the executive, the Chief Justice of India. And Chief Justice of India will consult 4 senior most judges of the Supreme Court, known as the collegium, and whatever name they recommend to the President, that's binding on the President. So today the judges are appointed by the President based on the recommendations of the collegium system, and this collegium system's recommendation is binding on the President. But yes, the President, what he or she can do, President can send the recommendation back. But the President will have to give it in writing. What are the objections of the executive? Why we do not want this particular individual to be appointed as the judge of the Supreme Court or High Court? But if the same name is reiterated by the Supreme Court collegium, the government has no other option but to appoint that individual. So long story short, we can say India is perhaps the only country where judges are appointed by themselves. But for that, the Supreme Court, the government, the executive, they have come up with something known as Memorandum of Procedure for appointment of the judges. And on this Memorandum of Procedure, there is a lot of debate, a lot of discussion, a lot of consultation going on. Some say that judges do not agree with these Memorandum of Understanding Procedure. Some say that the government is not following this Memorandum of Procedure. But be that as it may, Memorandum of Procedure exists. And according to that, whenever there is a vacancy expected to arise in the office of the judge of the Supreme Court, the Chief Justice of India will initiate the proposal and forward his recommendation to the Union Minister of Law, Justice and Company Affairs to fill up this vacancy. And that is why we say the statement is correct. Because who has the power to initiate the process of filling the vacancy? That power is with the Chief Justice of India at the Supreme Court. and if there is a vacancy in a high court, the Chief Justice of that high court will initiate the process of filling up this vacancy, telling the Supreme Court Collegium that we have a vacancy, please send recommendation to the President and we have to appoint someone to this vacant post. Clear? The appointment of a judge to a high court cannot be challenged in the Supreme Court after the name is approved by the Supreme Court Collegium. And we witnessed something recently where an advocate of Madras High Court, Miss Victoria Gowri, her name was recommended by the Supreme Court Collegium to be appointed as the judge of the Madras High Court. But then there was a petition filed in the Supreme Court challenging the recommendation of the Collegium, challenging the appointment of Miss Victoria Gowri. Why? Because it was alleged that she has indulged in hate speeches against some sections of the society, which makes her unsuitable to be appointed as the judge of the Madras High Court. But the Supreme Court rejected this petition. Supreme Court said we can only look at eligibility, not suitability. That means who is eligible to be appointed as the judge of a high court should be the citizen of India and should have been an advocate in one or more high courts for 10 years. If not, you should be the citizen of India and must have held a judicial office for 10 years. These are the only two qualifications for a judge of the high court. But when it comes to the judge of the Supreme Court, what are the qualifications? You should be the citizen of India and you must be the judge of one or more high courts for 5 years. If not, you should be the citizen of India and should have been the advocate in one or more high courts for 10 years. If not, then you should be the citizen of India and in the opinion of the President of India, you should be a distinguished jurist. These are the qualifications. So you can challenge the appointment of a judge only if that judge is not eligible, if that candidate is not eligible to hold that post. You cannot challenge it on the ground that that particular judge may not be suitable for that particular post, maybe because of some of the speeches that candidate may have made. That means the appointment of a judge to a high court can be challenged in the Supreme Court even after the name is approved by the Supreme Court Collegium. So which of the following statements are correct? A, only one is the right answer. NJAC and Collegium is not the same because after the third judge's case in 1998, in 2014, Constitution was amended. 99th Constitutional Amendment Act was passed and a body NJAC, National Judicial Appointments Commission, was set up. And this NJAC was sought to replace the Collegium system. This NJAC would consist of Chief Justice of India, two senior most judges of the Supreme Court, the Union Minister for Law and Justice, and two eminent persons. These two eminent persons should have been appointed after consulting a committee consisting of Prime Minister, Chief Justice of India, and leader of opposition in the Lok Sabha. But then in 2015, in a case known as Fourth Judge's Case, which is famously known as the Fourth Judge's Case, the Supreme Court struck down NJAC, saying NJAC violates basic structure of the Constitution. The Supreme Court said NJAC violates independence of judiciary, which is part of the basic structure. NJAC violates primacy of Chief Justice of India in judicial appointments, which is also part of the basic structure of the Indian Constitution. Okay. Let's look at question number 5. After a name has been recommended by the Supreme Court Collegium to the government for the post of a judge of a Supreme Court or High Court, the objections raised by the government are forwarded to the Collegium, which shall not reveal the content of such objections. And we have witnessed something unprecedented recently. 3 names were recommended by the Supreme Court Collegium to the government for appointment. One was to be appointed to the Delhi High Court, the another was to be appointed to the Madras High Court, the another was to be appointed to another High Court, and the government raised some objections. Although these objections are meant to be secret, but this time the Supreme Court did something unprecedented which has never happened in the history of independent India. The Supreme Court put out on its website the objections raised by the government. In one instant, the government had said that a particular name which you have recommended, he is openly gay and his partner is a Swiss national. That is why we object to this name. In another case, an advocate who was considered for the post of a judge, he had put out some tweets which are critical of the Prime Minister. And the government said, this person is openly an activist. We don't agree with this name. In another case, the advocate had made some speeches, also had posted some links of some articles from Quint.com, an online news portal which was critical of the Prime Minister. And these were the objections raised by the government. And something unprecedented happened. All these objections were revealed by the Supreme Court Collegium on its website, saying these are the objections raised by the government. And these names are still pending. They have not been appointed to the respective high courts. So statement number one, after a name has been recommended by Supreme Court Collegium to government, the objections raised by the government are forwarded to the Collegium, which shall not reveal the contents of such objections. This statement is incorrect because the Supreme Court Collegium has revealed the contents of these objections, and it is not mentioned anywhere that the Supreme Court Collegium should keep these objections secret. Question statement number two, Allahabad High Court is the only high court in India with a sanctioned strength of more than 100 judges. If you look at the high courts in India, Allahabad High Court has a strength of 160 judges, 120 permanent, 40 additional judges. After that, we have other high courts. For example, we have the Bombay High Court, which has 94 judge strength. After that, we have Punjab and Haryana High Court with close to 85 strength of the judges. Then we have Madras High Court with close to 74-75 judge strength, which means Allahabad High Court is the only high court in India with a sanctioned strength of more than 100 judges. So this statement is correct. Delhi is the only union territory with its own high court. If you look at union territory, under whose jurisdiction does a particular union territory come? For example, we have Lakshadweep. It comes under the jurisdiction of the neighboring high court, which is the Kerala High Court. Similarly, we have Puducherry. It comes under the jurisdiction of the neighboring high court, which is the Madras High Court. Similarly, we have Andaman and Nicobar Islands. It comes under the jurisdiction of the neighboring high court, which is the Calcutta High Court. Chandigarh, for example, it comes under the jurisdiction of the Punjab and Haryana High Court. Ladakh, for example, it comes under the jurisdiction of the neighboring high court, which is the Jammu and Kashmir Union Territory High Court. Which means Delhi is not the only union territory with its own high court. Delhi has its own high court, but Jammu and Kashmir Union Territory also has its own high court, which means statement 3 is incorrect. Which of the above statements given are correct? A, only one is the right answer. Okay. Let's look at question number 6. Which of the following statements is or are correct? Again, there has been a lot of controversy on a lot of tussle between the government and the judiciary, considered to be the crisis between the executive and the judiciary. And some members of the executive have raised concerns about the number of holidays that are taken by the judges of the Supreme Court. And they argue that the number of cases are pending for a long time in the courts because of the frequent holidays taken up by the judges of the Supreme Court and High Court. Statement number 1, the Supreme Court has 193 working days in a calendar year for its judicial functioning, while the High Courts function for approximately 210 days. This statement is correct. High Courts have the power to structure their calendars according to their service rules. This is also correct. It does not mean that every High Court will have to align its calendar, holiday calendar with the calendar of the Supreme Court. High courts will have their own holiday cycle as well. So which of these statements are correct? C, both 1 and 2 is the right answer. Yes, there are 25 high courts in this country. Question number 7, which of the following statements is or are correct? The Chief Justice of India, the Chief Justice of the Supreme Court, can direct a retired judge of the Supreme Court or a High Court to act as the judge of the Supreme Court for the temporary period. Statement 2, according to the Constitution, the President administers oath to the Chief Justice of India, who in turn administers oath to other judges of the Supreme Court. Tell me, what is the right answer? The Chief Justice of the Supreme Court, yes, but can request, cannot direct. For example, we need quorum. We need minimum number of judges who can function in the Supreme Court, who can take up the cases of the Supreme Court. For example, if we need the services of a retired judge of the Supreme Court or a retired judge of the High Court, then what Chief Justice of India will do? The Chief Justice will request that retired judge, can you please sit on the Supreme Court for a temporary period? But in this request, you have to also consider the consent of that judge whom you are requesting, as well as the consent of the President of India. So the Chief Justice of India cannot direct, because if it is direct, then it is binding on that judge to come on the Supreme Court bench and sit for a temporary period. The Supreme Court Chief Justice can only request. That too with the consent of that judge should agree, and also with the consent of the President of India. That is why we say this statement is incorrect. Number 2, according to Constitution, yes, President administers oath to the Chief Justice of India. Then you might also have noticed that recently many judges to the Supreme Court were appointed, and the oath was administered by the Chief Justice of India. But it is not by the Chief Justice of India, it is basically by the President. And President would ask the Chief Justice of India, on my behalf, you administer oath to other judges of the Supreme Court. So according to the Constitution, President will administer oath to all the judges of the Supreme Court, to all the Chief Justices, to the Chief Justice of the Supreme Court as well. And for a Chief Justice of a High Court, the oath is administered by the governor of that state. So according to Constitution, President administers oath to the Chief Justice of India, who in turn administers oath to other judges? No, that is not according to the Constitution. That is according to the conventions that we follow. The President would ask the Chief Justice to administer oath to other judges of the Supreme Court. So this statement is incorrect. Which of the following statements are correct? D, neither 1 nor 2 is the right answer. Great. Question number 8. Which of the following statements is or are correct regarding Article 142 of the Constitution? And I've deliberately given this question because some students would get a sense that this article is only about something known as complete justice. According to Article 142, there are 2 important things under it. 1, Supreme Court may pass such order as is necessary for doing complete justice in any cause or matter which is pending before it. And Supreme Court has invoked Article 142 number of times in the recent past. For example, a couple of days ago, the divorce between man and a woman was finalized by the Supreme Court by issuing the order under Article 142. Previously also, under anti-defection law, it's a curious case. Under anti-defection law, a defector is to be disqualified. Disqualification will be done by the Speaker of the Legislative Assembly. But anti-defection law does not mention the time period within which the Speaker has to take the decision whether this person should be disqualified, this legislator should be disqualified under anti-defection law or not. So there is no time period. There was one member of the Legislative Assembly in Manipur who was elected to the Manipur Legislative Assembly on the ticket given by the Congress Party. T. Shyam Kumar is his name. Then he defected, joined the BJP, and he was appointed as a minister as well. He was appointed as Forests Minister in the Manipur government. Matter went to the Speaker. The Speaker was asked, please disqualify Mr. T. Shyam Kumar because he has violated the provisions of the 10th schedule of Indian Constitution. But because of the absence of a time limit, the Speaker was dilly-dallying, not taking any action. Matter went to the Supreme Court. Supreme Court asked the Speaker to act on this. Supreme Court, the Speaker is still not acting on this disqualification petition. And after a few hearings, the Supreme Court said enough is enough. One judge of the Supreme Court was Justice Rohinton Fallinariman, and the Supreme Court invoked Article 142 so as to give complete justice and removed T. Shyam Kumar as a minister and told T. Shyam Kumar that now you cannot enter the Legislative Assembly unless and until the Speaker takes the decision. And then the Speaker took the decision and disqualified T. Shyam Kumar as the member of the Manipur Legislative Assembly. So Article 142 also was used in case of the Ayodhya judgment, where the Muslims were given 5 acres of land at a prominent place in Ayodhya because the Supreme Court said they have lost their place of worship because the Babri Masjid was demolished in 1992. Be that as it may, Article 142 is not only about giving complete justice. What is it about also? The Supreme Court shall have every power to make any order for the purpose of securing attendance of any person. The Supreme Court can invoke Article 142 and seek your attendance before the court. Discovery or production of any document. How have you gone ahead with a deal between the government and the government of France? Let's say the Rafale deal, we need these documents. The Supreme Court can invoke Article 142, calling for the discovery or production of any document, or can order investigation, or can punish people for committing contempt as well under Article 142. So Article 142 is about both these statements. So both these statements are correct. C, both 1 and 2 is the right answer. Done? So please tell whether Chief Justice and other judges of High Court are nominated by President or Governor of the respective state. They are appointed by the President. They're not nominated. They're appointed by the President. The High Court Chief Justice is administered oath by the Governor of that state. Okay. Question number 9. To be designated as a senior advocate of the Supreme Court, the committee responsible for such a recommendation includes which of the following individuals? And please listen to me carefully. This is a very important topic because the senior advocate of the Supreme Court has been in the news. The government wants change in the way senior advocates are designated by the Supreme Court. So very important news. And how the senior advocates are designated, it is because of the judgment given by the court in 2017. It's based on the petition filed by senior advocate of the Supreme Court, Indra Sawhney. According to this, a senior advocate is designated by a committee, and this committee consists of Chief Justice of India, 2 Supreme Court judges, and the Attorney General for India as well, 1 member of the bar which is appointed, nominated by this committee. It will not include the President of the Supreme Court Bar Association. So 1, 2, 3, 4, A is the right answer. And the rules say of 2017 that this will also have a secretariat. This committee will also have a secretariat, and they will meet at least twice a year. They will meet at least twice a year to decide and designate advocates of the Supreme Court as the senior advocates. But now I will give you another question. In order to be appointed or designated as a senior advocate, listen to me carefully. Can High Court Chief Justice or High Court judges be designated as senior advocates? Yes or no? Yes, yes, no. Do you also not know that there is a bar on the practice by the former judges? So Supreme Court judges cannot practice in the Supreme Court. But High Court judges can practice in the Supreme Court. High Court judges, after their retirement, they can practice in any other High Court where they have not served. That means this committee, which is consisted of Chief Justice of India, 2 senior Supreme Court judges, Attorney General, a member of the bar, they will come together. They will be assisted by a secretariat. They will meet twice a year. And in this twice a year, they will designate some important individuals as the senior advocates. Those who have the standing of minimum 10 years. Those advocates who are standing before the court for a minimum period of 10 years. And those who are considered worthy of such a designation. And at the same time, this committee can also designate a former Chief Justice of a High Court, former judges of the High Court who can practice in the Supreme Court as senior advocates. And now the government wants the Supreme Court to change these rules because the government says that this entire process is opaque. It can lead to nepotism as well. That is why the government is asking the Supreme Court to consider changing these rules. And that is why the designation of senior advocate becomes an important question for your prelims examination. Done? Great. Let's look at question number 10. And this is related to the police encounter, or what some people are alleging, the fake encounter that takes place. Which of the following statements is or are correct? An FIR must be registered in case of an encounter death, followed by an independent investigation by either the Criminal Investigation Department or a team from any other police station. Statement number 2, the information regarding an encounter death should be sent to the National Human Rights Commission or the State's Human Rights Commission. Statement 2. Statement 3, 6 monthly statements should be sent to the NHRC of all cases where deaths occurred due to police firing. And we have witnessed something which happened in Telangana, which happened in UP, which happened in some other places as well, encounter deaths. Any death which happens in the police station, police lockup, or under the custody of the police has to be investigated by either the CID or by other police station. And this report should be sent to NHRC as well. All these statements are correct. D, all of the above is the right answer. But what about NHRC? It can also be an important topic that can be relevant for your upcoming examination. National Human Rights Commission, I told you at the start, it is a statutory body. Statutory body means it is created on the basis of the law passed by the Parliament. And what is that law? Protection of Human Rights Act. The year was 1993. And in 2019, some changes were made to this law. NHRC, because of the encounter killing, is in the news. Since changes were made to NHRC in 2019, this topic becomes important for your examination. Prior to that, the chairperson, prior to 2019, the chairperson had to be ex-Chief Justice of India. Prior to the changes made in 2019, the chairperson of the National Human Rights Commission necessarily had to be the former Chief Justice of India. Similarly, the chairperson of the State Human Rights Commission necessarily had to be former Chief Justice of any High Court. But the changes made in 2019, it now says the chairperson of the National Human Rights Commission can be either the former Chief Justice of India or a judge of the Supreme Court. That is how Justice Arun Mishra, who was not the Chief Justice of India, is now the chairperson of the National Human Rights Commission. Why? Because now the eligibility has changed, the qualification has changed. The chairperson has to be either the former Chief Justice of India or a judge of the Supreme Court. That's number one. Number two, for a High Court Chief Justice or a judge of a High Court can now be appointed as the chairperson of the State Human Rights Commission. But these are not the only changes. Previously, there used to be 2 members who were appointed to National Human Rights Commission prior to 2019. Those members who have the knowledge of human rights. Now in 2019, the changes say 3 members should be appointed to NHRC. Not just this, at least 1 shall be a woman. Another change that was made in 2019. And then there are some known as deemed members. Can anybody tell me who are these deemed members or ex officio members of NHRC? There are 7 ex officio members of NHRC. Who are these 7 ex officio members? By virtue of them holding an office, they are considered to be automatically the members of the NHRC. Who are these individuals? Chairperson of National Commission for Scheduled Caste, National Commission for Scheduled Tribes, National Commission for Backward Classes, National Commission for Minorities, National Commission for Women, Chairperson of the National Commission for the Protection of Child Rights, as well as the Chief Commissioner of Persons with Disabilities Commission. These are the 7 members who, by virtue of holding an office of the chairperson of the National Commission for Scheduled Caste, Scheduled Tribe, Women, Minorities, Backward Classes, Chief Commissioner of Persons with Disabilities Commission, these are the deemed members of National Human Rights Commission. That's another important point that you must keep note of. Not just this, to this National Human Rights Commission, can you appoint a sitting judge of the Supreme Court as its chairperson or as a member of National Human Rights Commission? Can it happen? Yes, it can. But if you are appointing a sitting judge of the Supreme Court, sitting judge can be appointed only with the consent of the Chief Justice of India. These are important details that you have to keep a note of. Yes, Madhusudan, permission from the Chief Justice of India. Now let's look at question number 11. Which of the following statements is or are correct? Every minor child of a person who renounces their citizenship shall cease to be the citizen of India. An individual who is conferred Indian citizenship through registration and naturalization must subscribe to an oath which is provided under Schedule 3 of the Constitution. Recently, in a parliamentary question, an answer was given by a minister wherein it was revealed that close to 2.25 lakh Indians last year have voluntarily given up their Indian citizenship. They have renounced their citizenship. That is why renunciation becomes important. You should know that we have Indian Citizenship Act of 1955, which regulates all matters related to the citizenship. And there are various ways by which one can acquire the citizenship of India. Which are these ways? Number 1, by birth. I told you yesterday as well, prior to 1987, whoever is born on the soil of India, regardless of the nationality of the parents, the child is an Indian. because we were following the concept of Yas Soli, which is the law of the soil. Whoever is born on the soil of India automatically, by virtue of the birth, becomes the citizen of India. But after 2003, now the rules say the child born on the soil of India can become the citizen of India if one of the parent is an Indian, or both parents are Indians, and one of the parent is an Indian and the other is not an illegal migrant at the time of the birth. So one way by which one can acquire Indian citizenship is through birth, by birth. Second is by descent. You are not born on the soil of India, but you are born outside the territory of India. For example, you are born in the United States of America, but both the parents are Indians, or one of the parent is an Indian. Can this child who is born to an Indian parent outside the territory of India also become the citizen of India? Yes. Through which route? By the route of descent. So if a child is born outside the territory of India, then within 1 year of that birth, if you register the birth of this child at an Indian embassy or at an Indian consulate, the child, by virtue of descent, by virtue of the fact that one of the parent is an Indian, the child is an Indian. But listen to me carefully. We do not follow a concept known as dual citizenship. You are only the citizen of India and you cannot be the citizen of any other country at the same time as well. But there is an exception. This child who is born outside the territory of India, if this child is born in a country which recognizes dual citizenship, for example, United States, which recognizes dual citizenship, this child, if the child is born on the soil of US, automatically the child is a US citizen. But since the child is born outside the territory of India, one of the parent is an Indian, this child can also register to become the citizen of India by virtue of descent. It is only in this case that we recognize dual citizenship. This child, till he or she attains the age of 18, will have dual citizenship. This child can be the citizen of India, can be the citizen of United States also. But once the child attains the age of 18, attains the age of maturity, then this child will have 6 months. Then this individual will have 6 months to decide whether you want to continue as the citizen of India or you want to give up Indian citizenship. So another way by which you can acquire Indian citizenship is by descent. Third way is by registration. Registration in the sense, there are these minor children. For example, minor child of a parent who has renounced Indian citizenship, they also lose their citizenship. So when the child was minor, their parents, they gave up Indian citizenship, they renounced Indian citizenship. Now what if this child wants to take the citizenship back? This child has the option of becoming the citizen of India again through registration. Or for that matter, there is a foreigner who has come to India, married an Indian. Once this foreigner has stayed in India for a certain period of time, let's say 7 years, then this individual can register to become the citizen of India. Similarly, by naturalization. And there are some strict conditions that you have to follow if you want to become an Indian citizen by naturalization. For example, Adnan Sami, he was not born on the soil of India. He was not born to an Indian parent outside India. He is not married to an Indian so that he can apply for Indian citizenship through registration. Although there are various ways, there are various categories of people who can apply for Indian citizenship through registration. But Adnan Sami became the citizen of India through naturalization. And for that, he should have stayed in India for 14 years. He should have the knowledge of any language which is mentioned under the 8th schedule of the Constitution. He should not be from a country where Indians are not allowed to become citizens. So there are various conditions to follow. And fifth one by which you can acquire Indian citizenship is by incorporation of foreign territory. And this is where we need to come across an important concept. Let's say, for example, tomorrow we acquire Pakistan. Does that mean all the citizens of Pakistan would automatically become the citizens of India? No. We may not want Imran Khan. We may not want Hafiz Saeed to become the citizen of India. So when a foreign territory has been acquired, has been incorporated into India, the government of India will specify who are these citizens of Pakistan who can now become the citizens of India. Others will not. So there are 5 ways by which one can acquire the citizenship of India. And there are 3 ways by which one can lose the citizenship. One is by renunciation. Renunciation is a voluntary act. And it is through this route that close to 2.25 lakh Indians have given up their citizenship. One is voluntary, which is renunciation. Second is through termination. If you have acquired the citizenship of another country and you have not given up the citizenship of India, the central government, the Ministry of Home Affairs will terminate your citizenship. Then there is a third way called deprivation. But only those citizens, listen to me carefully, only those citizens of India who have acquired Indian citizenship either through registration or naturalization, but it is realized now that they are disloyal to the Constitution. They have acquired citizenship through fraud, through concealment of facts, then they can be deprived of their citizenship. Similarly, those who have stayed out of India for 7 years continuously, their citizenship can be deprived. These are the 3 ways by which one can lose their citizenship. What is the question? Every minor child of a person who renounces their citizenship shall cease to be the citizen of India, correct? But later on, you can register to get your citizenship back. Second, an individual who is conferred Indian citizenship through registration and naturalization must subscribe to an oath which is provided under Schedule 3 of the Constitution. Yes, oath is necessary, but this oath is not mentioned in the Schedule 3 of the Constitution. This oath is mentioned in the citizenship rules. That is how Adnan Sami, when he was given citizenship, granted citizenship, he subscribed to an oath before the Home Minister, then Home Minister, Mr. Rajnath Singh. But that oath is provided in the rules, citizenship rules, not under the Schedule 3 of the Constitution. Which of these statements are correct? A, only one is the right answer. Yes, second statement is wrong. Sir, if an independent MP is campaigning or attending the meetings of a national party after 6 months of being elected, does it lead to disqualification under 10th schedule? No, because you have not joined that political party. You're still an independent candidate. Okay. Question number 12, which of the following is or are the benefits of an overseas citizen of India card holder? There used to be a scheme known as Person of Indian Origin, which started in the year 2002. Then another scheme was launched, Overseas Citizen of India, in the year 2005. The distinction is that the PIO scheme was launched by Ministry of Home Affairs. An Overseas Citizen of India scheme was launched under the Indian Citizenship Act of 1955. And then in the year 2015, both these two cards were merged. Merged in the sense, now we have only Overseas Citizen of India card holder scheme. And those who had the PIO card, they can convert that card into Overseas Citizen of India card holder. The difference was the PIO can enter India without any visa for 15 years, for example. But the Overseas Citizen of India can enter India without any visa for life. Lifelong free entry into India. And at the same time, this PIO card holder had to report to the police authorities if the stay was for more than 6 months. But the Overseas Citizen of India card holder, he could have come to India no matter what is the duration of your stay, whether it is 6 months or less than 6 months or more than 6 months, there was no need to report to the police authorities. And now recently we saw something else. That is why this topic becomes important. 2 important developments have taken place. One actor, a Kannada actor, his OCI card was dissolved, taken away. And at the same time, we have seen that there were some OCIs who petitioned various courts in India saying we need parity with NRIs. when it comes to NEET examination. We want to take NEET examination. We want to apply for the Indian medical colleges under the NEET exam. So NRI seats, we want to compete for those NRI seats as well. And the government said, yes, these OCIs, they can come, they can take part in the medical examinations and they can compete, not for the free seats, not under the free seats, but for those seats which are reserved for the, which are set aside for the NRIs. Which of the following are the benefits of overseas citizen of India card holder? Multiple entry, multi-purpose, lifelong visa to visit India, correct? Exemption from reporting to police authorities for any length of stay in India, correct? Parity with NRIs in financial, economic and educational fields, this is also correct. But they cannot buy agricultural land without the permission. So select the correct option from below. D, all of the above is the right answer. Done? All are correct. Shreya is right. Let's look at question number 13. Which of the following statements is or are correct? Number 1, only the important cases heard by the Supreme Court are live streamed. Number 2, Supreme Court in Swapnil Tripathi case 2018 had ruled in favor of live streaming. 3, high courts in India are yet to live stream important cases. Select the correct option from below. I'll give you 1 minute to answer this question. Only 2, C, B, C, C, C. Only the important cases heard by the Supreme Court are live streamed. Incorrect. Not the important cases. Constitution bench cases. And which are these Constitution bench cases? According to the Constitution, a case which involves interpretation of the Constitution should be heard by the minimum of 5 judges. And now we have witnessed that all these Constitution bench cases, they are live streamed on Supreme Court, on the Supreme Court website as well as on YouTube. So only the important cases heard by the Supreme Court are live streamed. It's incorrect. Only the Constitution bench cases are live streamed. Supreme Court in Swapnil Tripathi case had ruled in favor of live streaming. This is correct. Justice Deepak Misra then was the Chief Justice of India. High courts in India are yet to live stream important cases. This is incorrect because the High Court of Gujarat, High Court of Jharkhand as well, they were initially way ahead of Supreme Court in live streaming the important cases. So which of the following statements are correct? C, only 2 is the right answer. Can you also tell me which was the first case which was live streamed by the Supreme Court? Which was the first case which was live streamed by the Supreme Court? Not Ayodhya. In fact, there were 3 cases which were live streamed simultaneously on a particular day, on the first day. One was the EWS reservation case, which was heard by Court 1 of the Supreme Court. Then there was another case which talked about the political crisis in Maharashtra. That case was also live streamed together. Or should we say Maharashtra political crisis? This can be important. Then there was another case which involved the validity of All India Bar Council exams. These were the 3 cases which were live streamed, the first ones to be live streamed by the Supreme Court. Question number 14. Which of the following statements is or are correct? Indra Sawhney versus Union of India 1992 case was heard by a bench of 9 judges. Janhit Abhiyan versus Union of India is a case in which the Supreme Court upheld the validity of EWS reservation. EWS reservation was upheld by the Supreme Court by a 3:2 majority. Which of these statements are correct? Reservation in India, an important topic because of the EWS reservation. If we strictly look at Article 16, Article 16 talks about there should be equality of opportunity when it comes to public employment. Article 16 further says that the state cannot discriminate the citizens only on the grounds of religion, race, caste, sex, place of birth, descent, residence. On these grounds, there can be no discrimination when it comes to public employment. But then exception was provided that those who are socially and educationally backward, and originally the Constitution said who are these people who are socially and educationally backward? Members belonging to SC and ST community. For them, there was reservation in public employment. Then came a committee known as Mandal Committee or Mandal Commission. It was set up with the task of identifying who are these people in India, apart from SCs and STs, who are also socially and educationally backward. Please identify them and suggest some measures by which we can enhance their standard of living. Mandal Commission said that there are close to 52% of our population, apart from SCs and STs, who are also socially and educationally backward. And those are what we can refer to as OBCs, other backward classes other than SCs and STs. And the Mandal Commission recommended that 27% reservation in government jobs should be provided to these OBCs. But this report was not accepted, was not acted upon by subsequent governments, by the government of, by the Morarji Desai government or the Janata Party government in 1979, or by the Indira Gandhi government, then Rajiv Gandhi government, and ultimately in the government of Mr. VP Singh when he was the Prime Minister, this Mandal Commission report was accepted and 27% reservation was provided to the OBCs. Then this matter was challenged in the Supreme Court. One lawyer, Indra Sawhney, approached the Supreme Court, filed a public interest litigation and challenged the 27% reservation in government jobs for OBCs. Then Mr. Narasimha Rao became the Prime Minister, and Mr. Narasimha Rao's government provided 10% reservation to poor in government jobs. All this was challenged in the Supreme Court in Indra Sawhney case. And what the Supreme Court did, this bench was of 9 judges. A 9-judge bench of the Supreme Court said OBC reservation of 27% is constitutional. But this OBC reservation is possible only if 5 requirements are met. Which are these 5 requirements? Number 1, you have to prove that these are socially and educationally backward. Number 2, you have to prove that they are not adequately represented in the administration. Number 3, you have to prove that you cannot cross reservation beyond 50% unless and until there are some extreme circumstances. The reservation cannot exceed 50%. At the same time, concept of creamy layer shall apply. That means those who are part of creamy layer within the OBCs, they will not get reservation. Only those who are part of non-creamy layer, they will get reservation. And all of this is possible if merit is not sacrificed. And that is something which is mentioned under Article 335 of the Constitution, that efficiency of administration should not be discounted. All this would then be possible. But Supreme Court in Indra Sawhney case, that is why this topic becomes important, Supreme Court said this 10% reservation for poor is unconstitutional. Then what was said by the Supreme Court in Indra Sawhney case as unconstitutional, how was it declared as constitutional in the last year's judgment in EWS case, in Janhit Abhiyan case? What was the difference? The difference was when 10% reservation was provided to poor in 1990s, that reservation was provided by the central government based on the resolution. That means an order was issued by the central government, not the law. Neither was the law passed, nor the constitution was amended. An order, a notification was issued by the central government saying 10% jobs will be reserved for the poor. The Supreme Court said, no, we can't do that, we can't allow you because this is unconstitutional. Because the Constitution recognizes only two kinds of backwardness: social and educational backwardness. Economic backwardness is not a ground on the basis of which reservation can be provided. So what was the different thing in 2019? In 2019, the Parliament of India enacted a Constitutional Amendment Act, amended the Constitution, and by 103rd Constitutional Amendment Act, it provided another category of economically weaker sections of the society. Now, economic backwardness is mentioned in the Constitution because of 103rd Amendment. And the Supreme Court upheld this constitutional amendment saying it is possible, it is doable, there is no illegality in this. And this judgment was given by 3:2 majority. There were 2 dissenting judges, but 3 judges said EWS reservation is constitutional. So statement number 1, Indra Sawhney versus Union of India. It was a case which was heard by 9 judges, correct? Janit Abhiyan versus Union of India 2022 is a case in which the Supreme Court upheld the validity of EWS reservation, correct? EWS reservation was upheld by the Supreme Court by a 3:2 majority, correct? So D, all of the above is the right answer. But listen to me carefully. EWS reservation will be given to those who are not the beneficiaries of existing reservation. That means those who belong to economically weaker sections of the society, but they should not be from SC, ST, OBC community. Because SCs, STs, OBCs, they are already getting the benefits of the existing reservation system. So that means people from the general category. And out of the general category, those who are economically weaker sections of the society, they will get the reservation. In fact, this matter was raised in the Supreme Court. How can you exclude the poor from SC, ST, OBC community? Why are you not providing poor of SC, ST and OBCs also the benefit of EWS reservation? The Supreme Court said, if we provide poor from SC, ST, OBC another reservation, then it would lead to double reservation because they are already getting reservation. If we give them reservation under EWS as well, then it would lead to double reservation, and that won't be justice. At the same time, the question was raised, how is it possible that you are violating the limit set by the Indra Sawhney judgment of 50% cap? Reservation cannot exceed 50%. So if SCs are given 15% reservation, STs are given 7.5% reservation, OBCs are given 27% reservation, that means close to 49.5% reservation. On top of that, you are adding 10% reservation for economically weaker sections of the society, which means you have crossed the 50% limit, which means that the reservation is close to 59.5%. How is that possible? The Supreme Court basically said that this 50% cap is for a reservation for socially and educationally backward class of citizens. For socially and educationally backward class of citizens, reservation cannot exceed beyond 50%. But additional grounds can be provided. Now additionally, EWS category has been created and you can breach the 50% cap, because in extraordinary circumstances, you can breach 50% cap because 50% cap is not part of the basic structure of the Constitution. Done? How can a 5-judge bench overturn a 9-judge bench order? In EWS case, it was heard by 5 judges, but they were not overturning the Indra Sawhney case. Indra Sawhney case was related to OBC reservation. This was specific to EWS reservation, another class. So that is why there is no such thing as judicial indiscipline. Okay. Question number 15. Which of the above conditions need to be fulfilled by the states in order to provide reservation to OBCs in the local bodies? Local body elections were to be held in Uttar Pradesh. Uttar Pradesh government said, because if you look at 73rd and 74th Amendment, 74th Amendment deals with urban local bodies, 73rd Amendment deals with Panchayati Raj institutions. In urban local bodies and Panchayati Raj institutions, there has to be reservation. What sort of reservation? Not less than 1/3 of the seats shall be reserved for women. It is necessary. You have to provide not less than 1/3 reservation to women. Also, you have to provide reservation to SCs and STs. What is the percentage of that reservation? In proportion to their population. Whatever their population, in proportion to their population, you have to provide reservation to SCs and STs. But can reservation be provided to OBCs? That is left to the discretion of the states. If the states want, you can provide reservation to OBCs in Panchayati Raj institutions as well as in urban local bodies. The year was 2022. Vikas Kishan Rao Gawali versus State of Maharashtra. The Supreme Court said you cannot provide reservation to OBCs to contest urban local body elections unless and until you follow a triple test. Unless and until this triple test is followed, you cannot provide reservation to OBCs in urban local bodies. And on that basis, when Uttar Pradesh also tried to provide reservation to OBCs in urban local bodies, the Supreme Court said you can't do that. Why? Because unless and until you implement and follow this triple test, you cannot provide reservation to OBCs in urban local bodies. And which is this triple test? Number one, the court said first you have to set up a commission. What this commission will do? Commission will look at the nature of backwardness. That when we look at these urban local bodies, is there representation from OBC community or not? If there is less representation, if we provide reservation to them, what will be the implication of that reservation? That means first you have to set up a committee. What this committee will do, this committee will conduct a survey, an inquiry. And basis that inquiry, it will look into the nature of backwardness, whether OBCs are represented adequately in urban local bodies or not. If not, if we give them reservation, what will be the implication of that reservation? Will that lead to the political empowerment of the OBCs? That is test number one. Then this body which has been set up, this body will also have to specify the proportion of reservation. What is the percentage of reservation that we should give the OBCs in urban local bodies? That is test number two. And test number three is very important statement. All the groups put together, not just OBCs, all the groups put together, whether SCs, STs, OBCs, the combined reservation should not exceed 50% of the total seats. That means all the seats that you are reserving in urban local bodies, give reservation to SCs, STs, that's mentioned in the 73rd, 74th Amendment. But if you want to provide reservation to OBCs as well, the combined reservation percentage cannot exceed 50%. This was the triple test which was proposed by the Supreme Court that needs to be followed by all the states when they have to provide reservation to OBCs in urban local bodies. Only when this triple test was followed by Uttar Pradesh, then Uttar Pradesh was able to provide OBC reservation in urban local bodies. So 1, 2, 3, D, all of the above is the right answer. Done? Can anybody regain his or her Indian citizenship if he voluntarily renounced citizenship but after some time he wants it back? Yes, then you can register for Indian citizenship. For that, you'll have to come and stay in India for 7 years and then apply for Indian citizenship. Can High Court Chief Justice become a member or chairman of NHRC? No, cannot become the chairman of NHRC. To become the chairman of NHRC, you have to be either the Chief Justice of the Supreme Court or a judge of the Supreme Court. Okay. Question number 16. The Essential Religious Practices Doctrine was introduced by the Supreme Court in which of the following cases? It's a very easy question. Let me know what is the right answer. "30 seconds for you. Some say Shabrimala, A. Sir, please explain lapse of bills. I'll do that immediately after this question. Don't worry, please. Okay. The Essential Religious Practices Doctrine was introduced by the Supreme Court in Shurur Mutt case. The year was 1954. An Essential Religious Practices Doctrine has been in the news because of the hijab controversy in Karnataka. The matter is right now before the Supreme Court. In PU colleges in Karnataka, the uniform was prescribed, and then there were people from the Muslim community, women, girls from the Muslim community who used to come to the colleges wearing the hijab. The school authorities, the college authorities, the state government also said, now you can't do that because uniform has to be uniform. And ultimately what happened? Matter went to the Karnataka High Court. Karnataka High Court said hijab is not an essential religious practice. When it is not an essential religious practice, that means you may be forced to not wear hijab inside the college as well. Because right from 1954, what Supreme Court has now done, Supreme Court will now be the deciding authority to declare what is essential to a religion and what is not essential to a religion. What is essential to a religion will get protection. What is not essential to a religion will not get protection. For example, the Shabrimala case, where the temple authorities had made rules. And these rules said a woman in the age group of 10 to 50 cannot enter the sanctum sanctorum of the Shabrimala temple because the deity, the presiding deity is Lord Ayappa. Lord Ayappa is a brahmachari, celibate, or Neshtika brahmachari, eternal celibate. Now the position before the court was, are these members, are these devotees of Lord Ayappa, is excluding women from 10 to 50 age essential religious practice? If it is, then the women cannot be allowed entry inside the sanctum sanctorum of the Shabrimala temple. And in 2018, in Shabrimala case, it was heard by 5 judges of the Supreme Court. 4 judges said this practice of not allowing women of menstruating age entered the sanctum sanctorum of the Shabrimala temple. This is not an essential religious practice. There was only one judge who dissented, Justice Indu Malhotra. Justice Malhotra said, what is religion to you may be superstition to someone else. So court should not be the final authority to decide what is essential and not essential to a religion. We should leave this matter to the devotees. We should leave this matter to the practitioners of that religion. They should decide what is essential and not essential to a religion. But now the Supreme Court gets to decide what is essential and not essential to a religion. And what is not essential to a religion will not get protection under the fundamental rights. Clear? Okay. So somebody said, what about the lapse of bills? Bills which lapse upon the dissolution of Lok Sabha. Lok Sabha can be dissolved. Ideally, Lok Sabha dissolves once the Lok Sabha completes 5-year term, because 5-year is the term of the Lok Sabha, but even before completing 5 years, the president can dissolve Lok Sabha on the recommendations of the Prime Minister. Clear? And when Lok Sabha is dissolved, there are all bills, all motions, all resolutions, all types of questions, they lapse. Except 3 types of bills, these do not lapse. 3 bills do not lapse upon the dissolution of Lok Sabha. Type number 1, bill which originates in Rajya Sabha and is pending in Rajya Sabha. Rajya Sabha is the permanent house of Indian Parliament. So this bill which has been introduced in Rajya Sabha and is pending in Rajya Sabha, since Rajya Sabha is the permanent house of Indian Parliament, this bill will not lapse. Number 2, bill on which there was a deadlock. And to resolve that deadlock, the President has notified joint sitting of the 2 houses. Listen to me carefully. Let's say, for example, there is a bill on which there is a deadlock, and we have discussed yesterday what leads to a deadlock on a particular bill. But if this bill on which there is a deadlock, this bill also will lapse. But if this bill on which there is a deadlock, the President has already notified joint sitting, and after the President has notified the joint sitting, then Lok Sabha has been dissolved, then this bill will not lapse. So a bill on which the President has already notified a joint sitting because there was a deadlock on this particular bill, this bill also will not lapse upon the dissolution of Lok Sabha. And then there is a third bill, the bill which is waiting for the President's assent. This bill also will not lapse upon the dissolution of Lok Sabha. So there are 3 types of bills which do not lapse. Bills which are originating in Rajya Sabha and are pending in Rajya Sabha, they do not lapse. Bills on which the President has notified joint sitting of the 2 houses of the Parliament, this bill also will not lapse. Apart from that, there is one resolution. Not just bills, there is one resolution which does not lapse. A resolution which calls for removal of a Supreme Court or High Court judge. This is not a bill, this is basically a resolution. This resolution also will not lapse, or this motion also will not lapse upon the dissolution of Lok Sabha. A bill which is passed by Rajya Sabha but is pending in Lok Sabha, it will lapse. A bill calling for the removal of judges also will not lapse. Am I right, sir? My dear, that's not a bill, that's basically a motion. A bill which is returned by the President for reconsideration of the House, yes. That's why I said a bill which is waiting for the President's assent, that does not lapse. Now, the President may want to send this bill back. The President can send this bill back. To whom? To Rajya Sabha, because Rajya Sabha is the permanent house of the Indian Parliament. This bill also will not lapse. Apart from this, every other bill lapses, or motion, resolution lapses. Now, question number 17. All fundamental rights are enforceable only vertically. 2. Only a fundamental right under Article 19 can be enforced even against persons other than the state or its instrumentalities. Which of the given statements are correct? Very important question. Tell me what is the answer. I'll give you 1 minute to answer this question. One minute to answer this question. Only 3 have answered this question. Okay. All fundamental rights are enforceable only vertically. What does that mean? Vertically and horizontally. When we look at part 3 of the Constitution, which talks about the chapter Fundamental Rights, Article 12 talks about the definition of state. The state shall not deny equality before law and equal protection of the laws. The state shall not discriminate. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this, the state shall not do that. Fundamental rights are enforceable against the state. And that is what we call the vertical application of fundamental rights. That means you can claim your fundamental rights if the state is violating it. And you can drag the state to the Supreme Court. And who is the state? The definition of that state is provided under Article 12. But there are some fundamental rights which are enforceable horizontally as well. For example, Article 15, Clause 2. Article 15 talks about that no citizen shall be discriminated by the state. The state shall not discriminate against its citizens only on the grounds of religion, race, caste, sex, place of birth. But the next clause, 15 Clause 2 says, no citizen shall be discriminated only on the grounds of religion, race, caste, sex, place of birth. When the citizen wants to access public property, burial grounds, bathing ghats, cremation ghats, public restaurants, public places of entertainment. And this Article 15 Clause 2 is considered to be an important article in our fight against untouchability. And then we have Article 17 as well, which says untouchability is abolished and its practice in all its forms is forbidden. That means fellow citizens also cannot practice untouchability. That is what we call horizontal application of fundamental rights. And now what the Supreme Court has done recently, Supreme Court was hearing cases related to hate speeches. If minister is indulging in hate speech, can we hold the government accountable for the speech made by the minister? That was the matter before the court. Another matter before the court was, if there is an individual who is holding an important office, freedom of speech and expression is mentioned in the Constitution under Article 19(1)(a), that every single citizen will have the freedom of speech and expression. But this freedom of speech and expression is not absolute. Why? Because there are reasonable restrictions. And these reasonable restrictions are imposed by the Constitution under Article 19 Clause 2. How many reasonable restrictions are imposed on our freedom of speech and expression? 8. Your freedom of speech and expression can be restricted on the grounds of sovereignty and integrity of India, security of state, friendly relation with foreign states, public order, contempt of court, defamation, incitement to an offense, morality or decency. On 8 grounds, your freedom of speech and expression can be restricted. Matter before the court was, for a public official, should there be an additional ground for restriction? Should more reasonable restrictions be imposed other than the reasonable restrictions under Article 19 Clause 2? This was the matter before the court. And what the Supreme Court did, although there was a dissenting judgment, Justice Nagaratna dissented in this judgment, but the majority opinion was that if a minister is making a speech, you cannot hold the government accountable for the speech given by a minister. And there is no need to have additional ground of restriction other than those mentioned under Article 19 Clause 2. But this Article 19, which is freedom of speech and expression, as well as Article 21 of the Constitution, will have the horizontal application as well. That means now even the private citizens, even non-state actors, you can drag them to the court, because if they violate freedom of speech and expression, if they deprive you of right to life or personal liberty, Long story short, fundamental rights are viewed primarily as claims against the state. If your fundamental rights are violated by the state, then you can drag the state to the court. But the court has now said that there are some fundamental rights, such as Article 19 and 21, which will apply horizontally as well. That means if the non-state actors also violate your Article 19 and 21, you can drag them to the court. Which means all fundamental rights are enforceable only vertically. Incorrect, because there are some which apply horizontally as well. Article 15 clause 2, Article 17, now Article 19 and 21 as well. Only a fundamental right under Article 19 can be enforced even against persons other than the state or their instrumentalities. Article 21 as well. Which means both these statements are incorrect. Which means D, neither 1 nor 2 is the right answer. Done? Atmanirbhar Bharat, you become Atmanirbhar with your bandwidth, and you'll be able to watch the video with good quality. Sir, kindly address my question. Recently, UP Legislative Assembly turned itself into a judicial body. How? Because it can also punish people for violating the privilege or committing contempt of the legislature. It was out of those 5 people, one has already retired, but they had beaten up some member of the Legislative Assembly who claimed violation of the privilege, breach of privilege by the police. And ultimately they were brought before the Legislative Assembly of Uttar Pradesh. Uttar Pradesh Legislative Assembly then became some sort of a judicial body because it can punish people for committing breach of privilege or contempt of the parliament. Okay. Question number 18. There is no concrete definition of hate speech under any Indian law. All the states and union territories are required to register hate speech cases even if no complaint has been made. Simple question. Let me know what is the right answer to this question. I'll give you a minute. (124) capital A deals with sedition. Sir, who can decide over a defamation case? Is it civil or criminal? Defamation is both civil as well as criminal. If I have defamed you, for example, you can approach the court and you decide whether you want to treat it as a civil defamation, wherein you want to seek compensation, or you want to treat it like you want to file a criminal defamation case, where you want me to be sentenced to a jail term. There is no concrete definition of hate speech under any Indian law, which is correct. That is why the courts rely on Section 153 capital A. The courts also rely on Section 295 capital A. What is Section 295 capital A of Indian Penal Code and what is Section 153 capital A of Indian Penal Code? If you are promoting enmity amongst the people on the basis of religion, race, language, place of birth, whether through your speech, through your articles, you are promoting enmity amongst the different sections of the society on the grounds of religion, on the grounds of race, on the grounds of place of birth, on the grounds of language, on the grounds of residence, then this is viewed as hate speech. Similarly, Section 295 capital A, when through your words or through your actions or through your articles, through your writings, you are criticizing religious figures or the religious practices of various religious communities, that is what is categorized as hate speech. But there is no concrete definition of hate speech under any Indian law. That is why the courts have to rely on section 153 capital A, section 295 capital A. And there was a petition before the court where initially the court asked the state of Delhi, the Union Territory of Delhi, the state of Uttar Pradesh, the state of Uttarakhand, that what you have to do, you have to register hate speech cases even if there is no complaint made. You have to tell us. You have to register the cases whenever hate speech has been made. But now Supreme Court last week has now asked all the states and union territories that what you have to do, you are required to register hate speech cases even if no complaint is made. And if you fail to register that case, you are liable for contempt. So there is no concrete definition of hate speech under any Indian law. It is correct. All the states and union territories are required to register hate speech cases even if no complaint is made. C, both 1 and 2 is the right answer. Okay? Let's look at question number 19. Consider the following statements. 5 zonal councils were established under the States Reorganization Act 1956. Union territories are not represented in the zonal councils. Union ministers are also invited to participate in the meetings of zonal councils. Each zonal council is an advisory body. What is the right answer? Only one statement is correct, 2 statements are correct, 3 statements are correct, all the 4 statements are correct. The year was 1956 when States Reorganization Act was passed. And because of this law, 14 states and 6 union territories were created. Because previously we had Part A, B, C, D territories in India. Part A were the big provinces which were under the Governor General, for example, Madras, Bombay, so on and so forth. Then Part B, there were those territories which were previously the princely states. For example, Jammu and Kashmir, Mysore, Hyderabad. Part C, there were territories such as Delhi, Coorg, which during the colonial period were under chief commissioners. Then in Part D, there was only one territory known as Andaman and Nicobar Islands. Then when the States Reorganization Act was passed based on the recommendation of the States Reorganization Commission, which was a 3-member body consisting of Mr. Fazal Ali, H.M. Kunzru, K.M. Panikar, then 14 states and 6 union territories were created. Clear? And then zonal councils were also created. 5 zonal councils were created. Northern, Southern, Eastern, Western and Central. But now we have a 6th zonal council as well. That 6th council, known as Northeastern Council, it was set up in 1972 on the basis of the Northeastern Council Act, Reorganization Act of 1972. So right now we have 6 zonal councils, but 5 zonal councils were set up under the States Reorganization Act of 1956. The 6th one was set up under the Northeastern Act. Clear? All these zonal councils, Home Minister is the chairperson. And this zonal council is basically an advisory body. It will advise the central government on various matters. Let's say there are various border disputes as well between 2 or more states. Advising the central government, that is the responsibility of the zonal council. And the zonal council was also in the news because of some problems between Assam and some of the northeastern states, as well as the Belagavi dispute. Belagavi dispute is between Maharashtra and Karnataka. When the States Reorganization Act was passed in 1956, and language became one of the grounds for reorganization, because the government accepted language can be the basis on the basis of which we can reorganize the states in India. That is how controversy also began, where Karnataka alleged that some of the Kannada speaking areas are in Maharashtra, Sholapur, Kolhapur and others. Maharashtra alleged that some of the Marathi speaking areas are in Karnataka, and one such dispute is on Belagavi. Belagavi is part of Karnataka, but Maharashtra claims it should ideally be part of Maharashtra. And then in 1966, under Mayor Chand Mahajan, a committee was set up by the then government. Mayor Chand Mahajan was the third Chief Justice of India. Previously, he was also the Prime Minister of Jammu and Kashmir. A committee was set up, and the job of this committee was to look into this dispute. And Mayor Chand Mahajan committee said that there should be ideally transfer of some land. That means some villages which are right now in Karnataka should go to Maharashtra. Some villages which are in Maharashtra should go to Karnataka. But Belagavi should stay with Karnataka. Maharashtra did not accept this. And ultimately in 2004, Maharashtra approached the Supreme Court and filed a petition under Article 131 of the Constitution. What is Article 131? Article 131 basically talks about that if there are some federal disputes involving center and states, disputes involving state and a state, all such disputes, federal disputes, can be filed only and only in the Supreme Court. And right now the Supreme Court will have to hear this matter, but this matter will be basically heard on maintainability. Maintainability in the sense, the Supreme Court will have to decide whether we can even accept this petition, whether we can even hear this petition. Because after all, it talks about reorganization of the states. But the petition has been filed under Article 131. Why zonal councils becomes important? Because under the States Reorganization Act of 1956, any dispute, border dispute, should go to the zonal council. And zonal council will then advise the central government and see if there is some sort of consensus. That is why zonal council becomes important for your examination. Who is going to be the vice chairman of the zonal council? Chief Minister on rotation. Chief Minister on rotation in the sense, if there is a Southern Zonal Council involving Tamil Nadu, Kerala, Karnataka, Andhra Pradesh. Today, the Zonal Council chairperson will be Home Minister, Vice Chairman can be the Chief Minister of Tamil Nadu. Next, Zonal Council meeting, the Vice Chairman can be the Chief Minister of Karnataka. So, by rotation, Vice Chairman will be appointed. So, 5 Zonal Councils were established under the States Reorganization Act 1956, correct? Union territories are not represented in zonal councils, incorrect, because union territories are also represented in zonal councils. Union ministers are also invited to participate in the meetings of zonal councils if necessary. If required, they are also invited to these meetings. There is no harm. Each zonal council is basically an advisory body, because whatever advice they give is not binding on the central government. Correct. So 3 statements are correct. C is the right answer. Okay. Question number 20. Sir Benegal Narsingh Rao, B.N. Rao, was the constitutional advisor to the Constituent Assembly. He's been spoken of and referred in lots and lots of articles these days. Sir B.N. Rao, he was the constitutional advisor to the Constituent Assembly. He was in fact once the Prime Minister of Jammu and Kashmir as well. He was also the judge of the International Court of Justice as well. It is also argued that he was a constitutional advisor for the setting up of the Constitution of Burma as well. Has played a spectacular role in drafting Indian Constitution. He basically said that in our Constitution there should be 2 types of rights. One should be justiciable rights, the other should be non-justiciable rights. Justiciable rights are fundamental rights. Non-justiciable rights are part of the directive principles of the state policy. Okay. When the Constituent Assembly met for the first time, the French practice of electing an oldest member as the temporary president was followed. Constituent Assembly met for the first time on December 9, 1946. And at that time, the oldest member of the Constituent Assembly, because Muslim League boycotted this first meeting of the Constituent Assembly, but whoever else participated, the oldest member was Sachidanand Sinha. And because there was a French practice that the oldest member should be chosen as the temporary chairperson, temporary head, Sachidanand Sinha was appointed as the temporary head of the Constituent Assembly. And then Dr. Rajendra Prasad was appointed as the president, elected as the president of the Constituent Assembly. So this statement is also correct. In fact, Constituent Assembly had 2 vice presidents as well. So which of the statements given above is or are correct? C, both 1 and 2 is the right answer. Question number 21. Azadi Ka Amrit Mahotsav is an initiative of the Ministry of Culture, Government of India to celebrate and commemorate 75 years of independence. So the stress here is on, is it an initiative of the Ministry of Culture or not? Tell me. The official journey of Azadi Ka Amrit Mahotsav commenced in March 2021. Which of the given statements above is or are correct? And while you are answering, if you are able to solve some of these questions, if you are able to learn some of the new things, or at least revise some of the things which you have already read, don't forget to press the like button. So let's say, as of now, I can see there are 348 likes. After my urging, let's see how many likes will we see. Azadi Ka Amrit Mahotsav is an initiative of the Ministry of Culture, yes, to commemorate 75 years of independence. The official journey commenced in March 2021. So you have to be sometimes absolutely clear about the year when it was commenced. This is also correct. So C, both 1 and 2 is the right answer. Nani Nobita has already liked. Nobita from Doraemon. Okay. Question 22. Fundamental duties are confined to only the citizens of India. The Swaran Singh Committee had suggested incorporation of 8 fundamental duties. Fundamental duties were not originally part of the Constitution. Fundamental duties were added. Part 4, capital A was added. Article 51, capital A was added. And this was done through 42nd Constitutional Amendment Act 1976. Clear? Initially, there were 10 fundamental duties added to the Constitution. Later, because of 86th Constitutional Amendment Act 2002, an 11th fundamental duty was also added. So in total now we have 11 fundamental duties which are part of the Part 4 capital A, Article 51 capital A of the Constitution. Clear? But these are applicable only to the citizens, not to the foreigners. And the purpose is to make citizens, is to play an educative role, is to make citizens aware, responsible citizens. Japan is the only other country which has a list of fundamental duties in its constitution, and we have borrowed the set of fundamental duties from the constitution of the erstwhile USSR. After the dismemberment of the USSR, now there is no USSR constitution. That is why we say Japan is the only other socialist country which has a list of fundamental duties. Clear? But this fundamental duty, you cannot file a mandamus. What do we mean by that? For example, if a public body is not doing its duty and thereby violating your fundamental rights, you can approach the Supreme Court under Article 32 and call for mandamus so that the Supreme Court can direct that individual, Supreme Court can direct that public authority, public body to perform that duty. But this fundamental duty, no mandamus can be issued by the Supreme Court. That means if I do not respect the living creatures, you cannot go to the Supreme Court and ask the Supreme Court to issue a mandamus so that I can have compassion towards the living creatures, which is one of the fundamental duty. So one thing that you have to keep a note of, no mandamus can be issued in this. So fundamental duties are confined only to the citizens of India. This is correct. Sardar Swaran Singh Committee had suggested incorporation of 8 fundamental duties. This is also correct. But then 10 fundamental duties were added. 11th was added in the year 2002. So in total, we have 11 fundamental duties. Okay. We have close to 3 minutes left now. If you have any questions, then please let me know. Then we will discuss tomorrow the rest of the questions. And tomorrow, unfortunately for me, fortunately for you, we have the last class on Indian polity. Parsis are not Muslims. It's a separate religion. The Supreme Court can issue any order so as to give complete justice under Article 142. Contempt of the Supreme Court and High Court we can discuss tomorrow. So please throw some light on the committee of the parliament. Which committee, my dear? No questions, thank you. Master of the roster. The Chief Justice of India has a judicial side to his role, giving justice to the people. But he also has an administrative side. Administrative side in the sense, he will assign cases to different judges. That is his responsibility. So I have 34 judges under me. I am the Chief Justice of India. This particular judge will hear election related disputes. Another judge will hear land acquisition related cases. Another judge will hear civil cases. Another judge will hear PIL cases. So assigning cases, responsibilities to individual judges of the Supreme Court, that is the job of the Supreme Court Chief Justice, where he is acting as the master of the roster. Roster system he decides. Is there any relation of Aadhaar to fundamental duties? Like what? What is going on between Judge of West Bengal High Court and the Supreme Court judges? An interview was given by one of the judges who was hearing a case in West Bengal, and the Supreme Court then said, you can't hear this case further because you can't give an interview on a case which is pending before you. CJ also gave an interview, but that was not interview on a particular case which was pending before him. So he was not discussing any case. He was generally discussing at India Today conclave, what is the status of judiciary. He was asked questions about the tussle between the executive and the judiciary, and look how beautifully he answered all these questions. So he was not basically giving an interview on a matter which is pending before him. So nobody asked him, how are you going to decide Eknath Shinde and the Uddhav Thackeray faction case? That would be improper. Okay, so let's meet tomorrow, 7:30 p.m. Till then, have a great time. But please don't forget to press the like button. Once the session is over, immediately drop in a comment. And today I'll have the responsibility of checking all these comments and replying to them. See you tomorrow, 7:30 p.m. Till then, have a great time. Good night.